We have a question that's coming on our website now, www.mbnow.in. Sridhar Reddy has written in and he wants to know, in a joint development project, why is service tax not applicable to the landowner if the developer hands over the project to the landowner as per the agreement?
Why is it applicable or not applicable?
Not applicable.
The question should be, why is it applicable? Because as of now, this service tax is applicable on this, and the department stand is, the tax department says that service tax is applicable on this. Now the question is that, or as I have understood the question, let me just take 2 more minutes because this is a little sensitive subject, and only last week, end of last week, there was a judgment of the Delhi High Court on this subject.
Right.
Which is very important.
I was just going to ask you about that High Court judgment. We spoke about it in our news bulletin today earlier today, and this is what we've understood from the High Court order that we've gone through. The Delhi High Court is essentially questioning the entire basis, the entire calculation of service tax on under construction property. Now, what the High Court says is that the cost of the property that you're buying is actually a sum total of the land cost, of the cost of the materials that have gone into the construction of the home, and the cost of the services that the developer is providing you to build that home and finish it and give it to you.
That's right.
So what the Delhi High Court is essentially saying is that in all of this, it is just the cost of the materials and the services that the developer provides, which should actually be taken into consideration when you calculate service tax. The cost of land is immovable property, and land transaction, buying and selling of land does not attract service tax. So essentially taxing that bit of the cost of the home is not right, and the math does not hold, which is what the High Court is saying, which is why they've essentially questioned it.
Correct.
Now, Pannkaj, taking this forward, what I want to ask you is this. This is a Delhi High Court order. How valid is it across India? It comes in an individual case, but is it valid to me as a home buyer sitting in Mumbai?
No.
It's not.
It is not valid across the country. It is, first of all, in the jurisdiction of the Delhi High Court, whatever transactions are there, they can perhaps rely upon on this judgment. But the Delhi High Court has basically stayed the operation of a particular explanation of the act. So therefore, only that explanation has been stayed, and therefore it would apply only to the jurisdiction in which it is the Delhi High Court operates.
But you know what? This order also comes on a central law. The service tax is levied under a central law. Yes. Now, there's one more interesting point that the Delhi High Court made. Pannkaj, I'm sorry, I need to just put this out. The Delhi High Court said that while service tax cannot be levied on the cost of the house, service tax can be levied on preferential location charges. Say you're paying floor rise to, buy a penthouse flat, then on these particular costs, service tax can be levied because here the developer is actually giving you a service. If he's making a garden for you to look at, it's a service that he's rendering to you. He's adding value to the product that he's giving you, and so there you are liable to pay service tax. The developer is well within his rights to levy that service tax and pay it to the government. Pannkaj, back to you. You were saying that it will not hold in the rest of the country.
My understanding is slightly different. Even on the preferential location, the Act specifically provides, the definition specifically provides. It is section 65 into bracket 105 into bracket ZZZH. The explanation to that, it provides that service tax is applicable on a preferential location charge. But however, when the person is choosing, when a buyer is choosing a preferential location, there is no additional service that the builder is giving you.
So you're saying that should not be charged.
There cannot be any service tax, and that is, according to me, that is what the Delhi High Court order says.
Pannkaj, very quick question, and we need to move on to our next question after that. If I'm buying a home, and this is what every home buyer has in mind right now, if I'm buying a home over, say, the next month or month and a half, do I have to pay the service tax then, after the judgment is coming?
Yes, unless you are located in the jurisdiction of the Delhi High Court. But
and even if, say, I am in Delhi, then?
Yeah, then perhaps you can take this on that, but you will have to proceed legally, because the department is not going to accept it as it is. There will be litigation, and there will be a lot of litigation. The matter will definitely go up to the Supreme Court, and that's where the finality will come, or the government will bring in an amendment and say that, okay, this is the thing. But that also I am afraid whether the government has the power to do it, because under the constitution, the government has no right to charge service tax on land.
Right.
Or any this on that. And to complete the answer before you move on to the next question, Sridhar, my point is that when you are the landowner and you have given the land in joint development, what you are getting the flats as in exchange of your land is the consideration of the land, and therefore in any case there it should not be chargeable. See, you have handed over the land in a joint development. The developer has developed it, and since he doesn't have the money, you have given in your land, and he gives you in exchange.
So can he challenge it if he's asked to pay service tax on this? Can he challenge it?
I'm sure it can be challenged.
So that's your answer there, Sridhar. You can challenge it, and as far as the other home buyers are concerned, unless you want to get into litigation, which Pannkaj says is very, very, and not just Pannkaj, a lot of tax experts we've spoken to today foresee a rash of litigations after this Delhi High Court judgment has come in. It's a very well thought out judgment, very watertight judgment in that sense. However, the judgment itself says that the government will have to legislate and make those changes.
Kavita, if you don't mind, I can just add one more line. You take an example of Bombay. You buy a house in Virar or you buy a house at Altamont Road. The value of land hugely differs. Okay. However, the service tax rate remains the same. Whether it is 1 crore or 5 crores or whatever the amount, you see, on the rate remains the same. Whereas the value of land fluctuates majorly. And therefore, indirectly, when the government is collecting more revenue, it is a service tax collected on the value of land, which is not correct.
Right. So it is not correct, but if you're willing to get into a lot of litigation, go ahead, don't pay that service tax. Otherwise, pay the service tax and or else, just wait and hope that the government brings in an amendment and, actually sees the merit in what the Delhi High Court has said, brings in a judgment and removes under construction property from the ambit of service tax.
You can watch live TV on our website mpnow.in. Find us on Facebook at facebook.com/magicbricksnow. And don't forget to click the like button. You can also follow us on Twitter at magicbricksnow. To stay updated with all our programming, hit the subscribe button on our YouTube channel by logging on to youtube.com/magicbricksnow.